Continue our conversation about Bill Cosby, now a free man. So what comes next? A few minutes ago, we mentioned the current district attorney of Montgomery County said he hoped the decision would not deter sexual assault victims from coming forward in the future. Is that realistic? And what does this ruling mean, since Cosby was one of the first celebrities tried in the wake of the Me Too movement? Joining us now, Stanford law professor Michele. Professor Dauber, nice to have you on the program. Just what happened here in terms of the legal community, but in layman's terms, what happened in Pennsylvania with this case?
Well, this was a bad decision by a court that really went out of its way to help Bill Cosby evade accountability. The decision makes no sense. It ignores deference to the trial court, particularly the determination that Mr. Castor, the district attorney at the time, was not credible, and it engages in gaslighting in many respects. So I think this is a terrible decision that harms women and sexual assault survivors.
Professor Dauber, those are pretty firm statements, what you're saying. Is this from your colleagues in the legal community? Do many of you feel this way?
You know, I haven't taken a poll, but this court seems to have determined that a press release is somehow a binding agreement that bars future prosecution, even though the press release said right in it that the DA could later change their mind as to the decision. So the press release was at best equivocal. Certainly there was no agreement. The trial court found that there was no agreement with Mr. Cosby. And found that Mr. Castor was not credible in his testimony. So I think most legal observers would find that this is a really surprising, bizarre decision. I would characterize it as bananas.
Would you bring this up to your law students in terms of a case study?
No, not really. But what I think is important about this case is the impact that this is going to have on women. A decision like this tells victims that even if they come forward, and even if there are 60 victims who come forward, they won't get justice, and their perpetrator will not be held accountable if they are rich and famous and well-resourced and important. I think the message this sends, much like the decision in the Brock Turner case, to privileged defendants is, don't worry, the system will have your back, even if there are 60 victims. And I think that is going to have a terrible chilling effect on victim willingness to report.
You referred to the Brock Turner case. That was the Stanford swimmer where you are on the Stanford campus. What do you tell women then? I mean, is it something where you don't just say, all right, let's give up here? What can be done moving forward?
Well, what I think this points really at the terrible way that the legal system has mishandled sexual violence from the top to the bottom. And it's very important from my perspective that women and survivors take direct action. That is, protest, vote, and make sexual violence a voting issue. Subject it to democracy. We need to make rape a voting issue, like abortion rights, like guns, like equal pay, like a lot of issues that matter to women's rights advocates.
And Professor, if I can jump in, how would you do that? If I can jump in, when you say we want to make rape a voting system, how would that work?
A voting issue.
A voting issue, I'm sorry.
And what I mean by that is let's vote district attorneys, sheriffs, and other elected officials who do not take sexual violence seriously. Let's vote them out, including judges. Let's vote them out. If they hold inappropriate attitudes about rape and will not protect survivors, then they should not be in public office.
All right, Professor Michele Dauber from Stanford Law, we appreciate your analysis and your time this evening. Thanks for joining us.